Hi, it's Mike DelSignore. In today's video, I want to talk about what happens if you're charged with indecent assault and battery in Massachusetts. So indecent assault and battery is an allegation that you touch somebody and there's an age component to it. The charge is based on whether the person's under or over 14. And that's, you touch them in an inappropriate place. It could be the genitals, the butt, the breasts, and it was unconsented. So in these cases, the main issue, the main goal is to find out why the victim would make this up. And that's going to be the focus of our entire investigation, our pretrial efforts, is to come up with a theory of why this is false. And we want to be able to tell that to the jury. And in a criminal case, you don't have to testify. But you might in this kind of case. This kind of case is one of those cases where sometimes people testify, some they don't. But our first goal is really to be able to prove this theory as much as possible without you testifying. So if there are other witnesses, documents, these cases, sometimes there'll be records. It's very difficult to get records in these cases. In other words, sometimes the alleged victim may be in counseling. And you would think, well, if they're in counseling, that could certainly show that they maybe misinterpreted the situation. Maybe there's another cause. Let's find out why they're in counseling. Well, the law basically makes it difficult to get these records because it says they're confidential, and it says you basically got to know what's in the records. You can't just fish for the records. Despite the right of confrontation, there is the law that really limits the ability to get these records. Now, I think that may change. While many people think that the new Trump justices, so to speak, on the Supreme Court are going to be anti-defendant, and in many cases they will be. I'm sure Miranda rights are going to be limited in search and seizure issues. On this issue of records, the Sixth Amendment, there is hope that their interpretation of the Constitution, saying the original meaning of the Sixth Amendment demands a right of confrontation, might have us rethink these cases where your right of confrontation is being denied and trumped by a right of privacy. Certainly is an important right, but there are ways where the court can look at these records in chambers to make a determination if they're relevant without sacrificing confidentiality. So that is our goal, is to find out why would the victim fabricate this charge. Some of the things that are going to happen. First, your first court date on this case is likely that there might be a bail. There could be a bail. It depends on the charge, but it wouldn't be uncommon for the bail to be $10,000. It could be $5,000. It could be personal. But bail might be certainly is in play. You're probably going to be ordered to stay away from anyone around the age of the victim. So if it's a victim who's 7, then you're going to have to probably stay away from any child under 16 or something like that. So there'll probably be conditions of release. These cases will get a pretrial date. They generally take some time to resolve. The DAs sometimes will reduce the charge to assault and battery, which is a great resolution because it doesn't require the sex offender registry consequences that an indecent assault and battery charge carries. So what we want to do is, one, see if we can resolve it without sex offender implications. If not, and a lot of times we can't, and we got to move forward with our defense. Hiring an investigator is key. While you're going to hire me for the case, I need someone to help me prove my case and to prove the theory of the case. So as a lawyer, I can't go out and talk to witnesses because then I can't be a lawyer. In other words, if a witness says something on the stand that's helpful, I need someone else to be there to corroborate that, to make sure the witness, if the witness doesn't say that, to impeach the witness and to gather independent evidence that would be admissible. So a lawyer can't be on both sides. So a lawyer can't say, ask the questions, and then if the witness says something that's different from what was said to an investigator, the lawyer can't say, well, you told that to someone else. At that point, now the lawyer is becoming a witness. So we have one job, and that's to defend you and be your attorney, but a witness is the one that provides evidence to the jury, and the jury would consider in determining whether it's proof beyond a reasonable doubt. These cases can get highly emotional, especially when the child is under 14. You have a young child. A lot of times there's family situations involved, and it's important to be able to dig through the details to find out what the motive is. Because without a compelling motive, it's going to be juries tend to believe victims. We got to be realistic about that, and the natural indications say, well, if this didn't happen, why would they make it up? So that's our goal. And we don't have to prove anything. The burden of proof is on the government, but the most effective defense gives the jury some information, a plausible theory about why this would be made up. If you have any questions, feel free to call me. My name is Michael DelSignore. I handle criminal cases, indecent assault and battery, sex crimes throughout Massachusetts. Be happy to help you. It's never too early, too late to call. My cell number, 781-686-5924. I'm here to help you. And if you have questions, don't hesitate to reach out.